All right, let's go on the record on cause number DC 1900359, Brandy Harris versus SB Premium LLC, DBA Suicide Bunny et al. Counsel, make your appearances.
Good morning, Your Honor. Matthew Brining on behalf of plaintiffs.
Good morning, Your Honor. Natalie Arledge also here on behalf of plaintiff.
Kathleen Cruz on behalf of defendants SB Premium and Tiffany and Larry Scott Gresham.
Whitney Warren on behalf of Triton Distribution, defendant in this case.
Okay, so we have a fairly extensive summary judgment, set of summary judgments in this case. I'm going to go ahead. I've read all the pleadings. The first thing I want to deal with is the defendant's amended joint motion to strike and objections to plaintiff's evidence in support of their response to defendant's no evidence motions for summary judgment and supplement thereto. Before we started, I kind of pulled up the checklist order on that. So let's kind of go through each of the exhibits you're objecting to. I believe Exhibit A is the first one, if you want to share screen that.
Yes, Your Honor. Everyone can see this Exhibit A? Okay. Yeah, so Exhibit A, we are objecting to it as it is not, there lacks any foundation or basic, any foundation or authentication that would otherwise constitute competent summary judgment evidence. And so we would ask that the court, we would object to it and request the court strike Exhibit A.
Response?
Your Honor, sorry?
Said response?
Your Honor, this is a statement of party opponent. This is prepared by and disseminated by Suicide Bunny. It's pulled from their, let's see. It says at the bottom, it's information brought to you by Suicide Bunny. It's a self-authenticating document. If the court needs a supplement to support this, a declaration saying this was retrieved on X date, we can provide that. But again, this is a statement of party opponent being offered against that party.
I noticed that there, right after this, there's an affidavit of Natalie Arledge, I believe.
Oh, yeah, so it's already there. It's authenticated through that declaration.
Okay. All right, I'm going to overrule the objection to Exhibit A. Let's go to Exhibit B.
Exhibit B, again, we would object to it as it lacks foundation. It's not, it's offered as scientific evidence without any expert testimony or anything or any other foundation as evidence in support of their claims. And we would request that it be stricken.
Does this have an affidavit that goes, is it the same thing or does it have an affidavit with it?
Rolling quickly. It does.
Can I see the affidavit, please?
Yes, Your Honor.
Yep, all right.
And Your Honor, I understand that the declaration shows that it was downloaded as a PDF. However, they are using it as scientific evidence without us being able to cross-examine the author or ask any questions about it. They're using these online articles as fact in support of their expert, as in replacement of an expert testimony.
All right, Exhibit B is overruled. The objection here is hearsay, so based on the objection, that's overruled. Exhibit E is the next one.
Yes, Your Honor. We had objected to E as we were unable to get to the video at the time, and we also believe that it's hearsay.
All right, that's overruled. J.
Your Honor, so Exhibit J is this Cutter Law e-cigarette testing. We objected to it as hearsay because it lacks any sort of authentication. We understand and is trying to prove the truth of the matter asserted. Again, we understand that there were supplemented exhibits P and R as a declaration in support of this. However, we've also objected to those declarations as failing to comply with the Texas Rules of Civil Procedure, Rule 21, because it requires an electronic image. We also object to it as it fails to comply with Section 132.001, which allows the declaration in place of an affidavit, and which goes into paragraph 5, which is it's not been authenticated and it's improper summary judgment evidence.
Response?
Yes, Your Honor. This was HPLC testing done at the direction of Dr. Onkeko, that is plaintiff's expert microbiologist. Defendants had a full and fair opportunity to depose Dr. Onkeko about this HPLC test at his deposition. This is the type of evidence that type of data and study that Dr. Onkeko would generally rely upon. We have a declaration from Dr. Son, the individual who performed this test. We have a declaration from both Brandy Harris and Faye Powell from my office establishing the chain of custody. This is fully authenticated and admissible evidence.
And
J
Your
is
Honor,
J is overruled. Let's go to Exhibit K.
again, Your Honor, Exhibit K is it's a video. It's taking notice of a journal article that we don't, that we've as scientific evidence without expert opinion or without us being able to cross-examine. And we also believe it's hearsay.
Response?
So K is not being offered for the truth of the matter asserted, that is, this one specifically, that is that the e-cigarette vapor is toxic. K is being offered to show that early on there was evidence, or there was data and publications out there available that the defendants should have known about that would have alerted them to the dangers of their product. So that the truth of the matter asserted, that the truth of the dangers is not at issue.
Are there any experts that rely on this article?
On Exhibit K, I do not believe that experts are relying on Exhibit K.
And there's no affidavit. I guess this is what you have as the notice. I'm going to go ahead and sustain on K. L.
Your Honor, this again relies on a CDC infographic. Again, we believe it's hearsay as experts didn't rely upon it, and we did not have the ability to cross-examine the author or and it's being stated for the truth of the matter asserted.
Response?
So first, the CDC infographic is a public record under Texas Rule 8038, and thus it is admissible. But also, I don't really think that Exhibit L, the infographic, is being relied upon for the truth of the matter asserted. That is, that these products are dangerous. It's being relied upon to show there was ample evidence out there while Mr. Harris was using these products and while the defendants were representing them that they were safe, that they actually were not safe. There's substantial evidence that defendants should have known these products were not safe as they marketed them.
No, for Exhibit L, the objection is overruled. Exhibit M.
Your Honor, we believe this has the same aspect of it. It's used for the truth of the matter, the truth of the matter asserted. It's,
Okay,
not,
that one's, okay, it's the same as L. I'm going to overrule. Let's go to O. Okay, so this is a research article. Is it relied on by an expert?
Yes, Your Honor. Dr. Onkeko.
Exhibit O is overruled. Exhibit P.
that is actually a separate file. Let me pull that up real quick.
I do want to commend you for navigating these exhibits so well. You're doing a good job.
And Ms. Warren, is Exhibit P and R, are those part of the amended objections that came in on Wednesday?
Yeah, we filed the amended objections on February 16th. Is everyone able to see the supplemental response?
Yes.
Okay.
This one may not be hyperlinked.
Yeah, no, it is not. All right, here we have Exhibit P, Declaration of Fay Powell. And we are objecting to it as it fails to comply with the Texas Rule of Civil Procedure 21F7, which requires an electronic image or scanned image of the signature if the document is notarized or sworn. And as such, the electric signature is not sufficient.
Response.
Your Honor, we can supplement with a wet signature. I mean, these are just declarations authenticating the transfer of the evidence. Again, I'm happy to provide a wet signature if that's what this issue is going to be based on.
And Your Honor, they've had, almost a month now since this was filed to supplement.
When was your objection made?
This objection was filed on February 16th, before the hearing, the hearing during the snowstorm.
And Your Honor, I will say it may be my fault. I was not aware of this objection until just now.
I'm gonna give an opportunity to pursuant to, I think it's 166A. I don't remember if it's F, but I'm going to allow you an opportunity to, I think this is a procedural defect, and I'm going to allow you to amend the affidavit.
Thank you, Your Honor.
And Your Honor, I believe there will be a similar ruling. We've also objected to Exhibit R for the same or similar reason. The typed out e-signature is insufficient for this declaration.
Same ruling. The testimony of Weg Ongeko, is that kind of the big issue that we have on the other motion? Oh, wow, we have a lot more.
And Your Honor, several of those objections, and I apologize for the detail of it, will likely, most of those relate to the exhibits, which you may have already ruled on, and also are in reference to sentences that have no summary judgment evidence cited to.
All right, let's go to testimony of Rutherford Weg Ongeko. Let's hear argument on that.
Your Honor, as stated, I think more fully in the defendant's joint motion to strike the testimony of Dr. Ongeko, we believe that his testimony for purposes of the summary judgment is inadmissible because it does not reliably demonstrate that vaping e-liquids causes cancer, or that defendant's e-liquids more likely than not cause Harris's.
Haven't I already ruled on the motion to strike for Ongeko?
Yes, Your Honor.
All right, it's overruled.
Okay.
Remember, I granted as the dentist, right?
Yes, Your Honor.
In part.
Yes, for Dr. Carter and Dr. Garza, they were stricken.
Regarding causation.
As to
Sorry.
causation.
Okay, so the next one then I should sustain then. To be consistent. And then Doctor, I've already ruled against y'all on Arambide and Mons, correct?
That is correct.
All right, so that's overruled.
Sorry, Judge, could you repeat those names?
Arambide, it's Arrambide, and Mons, Mons.
Thank you.
Next, we have paragraph 5. I don't know what that's referring to exactly.
Yes. So let me pull that back up. Sorry. My apologies.
That's okay. Oh, these are asking to strike out directly out of the.
Yes, Your Honor. Yes. And several of these items likely have been
Ruled on. Okay, I'm going to overrule all of these. All right, and then we have, okay, the footnotes, and then there's a declaration as well.
Yes, Your Honor.
So that's the issue of whether or not it's late.
Yes, Your Honor.
So what's your argument on that?
Your Honor, the affidavit or the declaration of Dr. Ongeko was not received or served on all counsel for this party until Monday afternoon, which is which is in non-compliance with Rule 166 AC, which requires all affidavits and testimony and evidence be filed and served on all counsel at least 7 days before the hearing. And counsel failed to do that and failed to otherwise notify any counsel of that until we were making the binders on Monday. And as such, we believe because it's a non-compliance and it's untimely, it should be struck from the summary judgment record.
Response?
Yeah, thank you, Your Honor. So this was, again, filed on Friday, which is timely. I have a receipt for that. I may be wrong, but my understanding is that generally when it's filed, that is automatically disseminated, although I know that Ms. Arledge could comment on that more than I could. But this was sent to, when we learned from defendants that they had not received it on Monday morning, Ms. Arledge sent them a copy immediately on that morning. There's no prejudice here. I mean, the declaration is Dr. Ongeko saying, yes, I rely on these articles. These are all articles that had previously been brought to the attention of defendants in our previous pleading. The fact that they received this declaration from Dr. Ongeko saying, yes, I reviewed and rely on these on Monday morning rather than Friday night, there's no prejudice there. And again, it seems like there was a administrative error. I guess one of the documents that was filed was accidentally password protected, which made some issue with getting it disseminated to all parties.
Response?
Your Honor, the rules are very clear about affidavits and declaration and the declarations in place of an affidavit. It must have been filed and served on March 5th, 2021. Plaintiffs did not ask for leave. They have not asked for a continuance in order to properly file and serve that declaration. Several of these administrative issues have occurred, and it does begin to prejudice opposing counsel when we are unable to have the time required to analyze and respond to briefing. And I will also say just the case law is on this topic is very, very clear on affidavits being served late.
All right, I'm going to go ahead and overrule the objection. All right, anything else on objections?
I believe, oh, yes, Your Honor. we did object to, this might be better spent when discussing plaintiff's motion for partial motion for no summary judgment.
Okay. All right, let's go ahead and get started. We have about 10 minutes left on this, so let's go ahead and get started. Unless, let me see, Ms. Coker, have you guys reached an agreement on your hearing?
Unfortunately not, Your Honor.
Okay,
I think we need a brief discussion.
okay. All right. So let's get to the merits. You can proceed. And I have read everything. So just hit your high points.
Your Honor, just to quickly go over in our claims at issue in both defendants' motions, no evidence motions for summary judgment, we have a design defect, marketing defect, breach of express warranty, and implied warranty of merchantability, as well as negligence. Very quickly, and because I did do a PowerPoint, but due to time constraints, I will just quickly go through everything.
Let me ask this.
Yeah.
So there's a number of different causes of action.
Yes, Your Honor.
I will say that I didn't see responses to all of the different causes of action. So
That's correct, Your Honor.
so which causes of action was there not a response to?
Your Honor, there was not a response to the manufacturing defect, which per their first submitted petition, they have removed that claim.
Okay.
And then there was not a response to the motion against their breach of express warranty claim. Although they did address the implied warranty of merchantability. I believe those are the claims I did not see a response to as well.
And are we talking now about defendants SB Premium's, Tiffany Gresham and Larry Gresham's amended no evidence motion for summary judgment?
I am discussing Triton Distributions. Ms. Cruz is counsel for the SB defendant.
I think Ms.
Yes.
Moore is speaking specifically about plaintiff's response to the no evidence motions for summary judgment against both defendants, but plaintiffs did not file a response to the SB defendant's traditional motion for summary judgment.
They haven't filed any response?
Not
So
to my knowledge, Your Honor.
Yeah, so Your Honor, so I can speak to that. The traditional and the no evidence, the arguments are all the same for everything.
Okay.
I'm sorry, Your Honor, may I interrupt just very quickly? We filed a response to their traditional motions back in 2019 when they were first filed for hearing. So we would just stand by that response.
Okay. I think what might work best is there a checklist order? Because there's quite a few different motions here as to each different motion and each cause of action as to each defendant.
There is not, Your Honor. I believe they are general orders related to each individual motion.
What might work best, I don't know how long how long it would take you to do one, but it might work best if I had a checklist order on this, just because there's so many different causes of action and so many different defendants. Unless there's some other way to easily kind of track this.
Yes, Your Honor, let me, it won't be pretty.
Okay.
I can attempt to do that very quickly.
Because if I have correctly, we have defendant wages and White Lions or DBA Triton Distributions. They have a motion for summary judgment, no evidence motion for summary judgment. You have plaintiff's no evidence motion for summary judgment. You have defendant SB Premium's motion for summary judgment. So I guess there's two separate sets of summary judgments on the defense side and one for the plaintiff. Why don't we go through, I guess, Ms. Warren, why don't you share screen for me? And let's go through, why don't you type out for Triton, do Triton, and then do SB Premium, and then each cause of action. We can just kind of do it that way. Does that make sense?
Yes, Your Honor. Let me.
You don't have to do a full order, but just some kind of checklist. And you're welcome to share screen.
Okay. Let me just make sure. Okay.
Or if it'd be easier for me to do it, I can do it too.
Lots of copying and pasting.
Perfect. Okay, great. So if you could put above that, is that SB Premium or Triton?
Your Honor, so Triton and SB Premium have essentially the same motions, same no evidence motions for summary judgment. And I believe this is the same causes of action at issue for both the sets of defendants.
Okay, so there won't be any real difference then. So marketing has already been granted because there's no response, right?
But
Manufacturing.
Sorry,
Yeah.
manufacturing has already been granted. I apologize.
Yes, Your Honor. So.
And then you said did not respond to express, but they did imply, or was it vice versa?
Yes, that's correct. They did not respond to express warranty.
Okay, so go ahead and put granted as to manufacturing and granted as to express.
Yes, Your Honor. And so then we have the plaintiff's partial no evidence
Okay.
motion for summary judgment. And that was against defendants, both sets of defendants.
It's okay. You know, you're doing it on the fly. You're doing a great job.
And Your Honor, I can shortcut this
Two
last one.
defendants,
We will only be
defenses
arguing.
of sophisticated.
Just arguing learned intermediary.
No, actually, the last one, the failure to mitigate.
So you're not going to be moving on learned intermediary or the sophisticated user.
Correct. In the interest of time.
Okay. So put withdrawn as to those.
And
Right, so-
and I apologize. There was a third one that we did not respond to, and we are withdrawing that as well, which is.
What's that?
It is the superseding cause. We withdrew it and are not objecting to it.
Okay, so I would put withdrawn by defense withdrawn by defendant. All right, let's go to design defect real quick.
Real quick, you type that under fail. Okay.
Yeah.
Just making sure. Okay.
Design defect.
Yeah.
And would you like to continue the screen share?
Yes, please.
Okay. All right. Design defect, just to keep it pretty short, the elements that must be proved are that there's a safer alternative design, there's a producing cause, and also that it's unreasonably dangerous. Under Texas standard, for a safer alternative design, product has a design defect in light of the economic and scientific feasibility of safer alternatives. Texas law does not require a manufacturer to destroy the utility of his product in order to make it safe.
It doesn't. don't they argue that low VG and VG free e-liquid produces less of the carcinogenic compounds compared to what y'all are doing, the defendants are doing?
Your Honor, yes, they speculate that that would make it safer. They, you know, we believe that these statements are speculation. It's a conclusory that it's feasible. There's no supporting evidence of that conclusion.
Doesn't Dr. Ongeko testify about that?
He testifies regarding the design of, he testifies regarding VG and VG free and the design of it, but he does not actually go into what the effect of reducing that amount in the vaping juices further, you know, further, there's no evidence that changing the PG or the VG would actually create the same product. It could create an entirely different product that would be, you know, not as popular, or there's no evidence whatsoever of what it would do to their product. And for that reason, we believe they have failed to prove that there's a safer alternative design beyond it is feasible.
I'm going to go ahead and deny on design defects. Let's go to marketing defects.
Your Honor, I can take that on as counsel for SB defendants because it was a marketing defect claim against both Triton and SB defendants. And in our response to the marketing defect claim, SB defendants did produce the warning labels and instructions for the subject vape juices, and that was attached as an exhibit to our response. And I can also share my screen if you would like to see the warning labels that we did produce. And
Go ahead.
I'm sorry?
Go ahead.
Okay, 1 second. Thanks, Whitney, for taking down your share screen. Okay. All right, Your Honor, can you see my share screen here? I'm going to make it bigger so we can see it. And this is the warning label that was on mother's milk. And this was on the vape juice in question that plaintiffs have not refuted that Mr. Harris received. The subject vape juices on all their packaging, on the vape juice bottle, they had this warning label. And it's specifically talks that this product can expose you to chemicals, including nicotine, which is known to the state of California to cause cancer and birth defects or other reproductive harm. For more information, it says do not buy if seal is broken. And it also even lists the ingredients: USP vegetable glycerin, USP propylene glycol, natural and artificial flavorings, and USP nicotine. And this is for the subject vape juice of mother's milk and also the Sucker Punch vape juice that's at issue in this case. This is also the same warning that was on the vape juices here. And plaintiffs haven't refuted that these vape juice warnings were on the bottles of the vape juices that Mr. Harris used. So the absence of a warning, plaintiffs have not established that there's marketing defect or an absence of a warning on these vape juices.
Response?
So this, as Your Honor can see, only warns about nicotine and it being, according to the state of California, a cause of cancer and birth defects. There's no warning whatsoever about the formaldehyde and acetaldehyde. Those are the two big carcinogens that are being released anytime these the e-cigarette vapor is heated. I think more importantly, though, there's nothing about this warning or anything the defendants did that would have indicated, and I have graphs here that I could show, but they all come from the articles cited in Dr. Onkeko's declaration. When you heat defendant's product and really pretty much any e-cigarette liquid to mid and high vaping settings, either power or temperature, that carcinogen level increases exponentially. So there's no warning that as you use this as intended at mid to high vaping settings, that level of carcinogens is going to increase. Dr. Onkeko Dr. Onkeko testified that based on the HPLC testing that was done, defendant's e-liquid was exposing Neil to between 5.8 and 33.7 packs of cigarettes per day worth of carcinogens. Nothing about this warning suggests to the reasonable user they would be exposed to that level.
So let me ask a question here, and this is kind of a big picture question because I think this is kind of a key issue. And this is not dispositive, I'm just trying to figure out where this fits, is this case is not part of an MDL, obviously. Is there an MDL on some of the other vaping cases?
Not that I'm aware of, no, Your Honor. Well, on Juul cases for lung disease, that sort of thing, I have not seen one on cancer being caused by e-cigarettes, but I haven't looked, honestly. And I think it varies depending on who is using the product, how often they're using it, use patterns, what ingredients are in there, whether it's high VG, high PG, a lot of different factors that I think may not work well with the NDL.
Are there any appellate opinions on any of these warning labels yet in other jurisdictions?
None that I'm aware of, Your Honor. But again, the e-cigarette device and popularity is still relatively new.
And Your Honor, if I may, that is what you were saying before, that is the crux of the issue here, is because e-cigarette smoking and vaping is so new, there is no evidence that the vaping is what caused cancer in this case. So that's why, and plaintiffs' experts have agreed to this, that just because it's so new, there aren't studies that support that vaping is what caused cancer. And that's kind of where we are at for the crux of the issue in our case.
And Your Honor, if I may speak to that.
No. That's not what I'm getting at right now. So these warning labels, were these approved by the Surgeon General or by the FDA?
Your Honor, yes, I believe so. Or they were required by the FDA.
There's no evidence of that, Your Honor. And I will say, specifically to this, this warning label is being put out at the same time that defendants are posting promotional videos saying that their product is safe and that their product, one of the defendants here is on video, talking about how people come up to her and say, "You're the reason I quit smoking. You're the reason I'm here for these kids," touting this as a life-saving device. The headline to this day on defendant's YouTube page is, "Your health and safety is our #1 goal." So they cannot square that marketing and those attempts that they're putting out there with saying, yes, this adequately warned Neil and the reasonable consumer they would be consuming deadly levels of formaldehyde and acetaldehyde.
Your Honor, may I briefly reply to that?
Okay.
Your Honor, counsel brings up these YouTube ads. These ads that they've put, or videos that they put into their pleadings, are from 2017 and 2018. And as such, they're irrelevant to this case. Mr. Harris started vaping in 2015. He ceased vaping in January 2017 after he was diagnosed with his cancer. So as such, I believe that these videos cannot be used to show that our clients, defendants, knew that the vape juice was dangerous. They did not know that. And they were not advertising that, and there's been no advertisements that have been shown that either Mr. Harris saw, relied upon, or existed saying those facts. And additionally, plaintiffs additionally relied on these two studies to show that this is foreseeable and supported their marketing defect claim. However, these studies are in 2014. There's no evidence that that defendant saw this study. It was or that it was released prior to Mr. Harris vaping, and a 2017 study, again, which is after Mr. Harris ceased smoking. So these examples of our defendant's alleged knowledge aren't relevant to the case.
Your Honor, the YouTube video I just quoted was from 2015. It's still on their website. It says the date that it was posted. It says in the video where they're at. That's one where the defendant is saying, people come up to me and say, you're the reason I'm here for these kids. And here, they're the reason Neil is not here for his kids. Regarding the...
All right, I'm going to overrule the summary judgment on this. I will say this, that for all of these, because it's so new, if there's any opinions that come out of other vaping cases, out of appellate courts, other places in Texas or around the country that rule on this stuff, I'd be glad to look at them in the future. But at this point, it doesn't sound like there's anything, and I don't think this is an adequate warning personally, or at least there's a fact issue on whether or not this is an adequate warning. So I'm going to go ahead and overrule. So let's go to the next one, Ms. Warren.
I will pull this back up. Okay.
So have you been updating the sheet, Ms. Warren?
Yes, Your Honor. I added some nice
All
things
right.
there.
So we have.
So you've ruled on breach of express warranty. As for implied warranty of merchantability, Your Honor, we believe that this is the wrong standard that they've used. In their response, they state that they don't have to have an expert opinion and that all they have to prove is that Mr. Harris properly used the e-liquid. This is not the standard for breach of implied warranty. While you do not have to have an expert opinion, then you do have to use proper use. The evidence in the record shows that Mr. Harris experimented, used different mods, used different vaping. We don't know if he used proper use. And plaintiff's motion states that there's just no dispute that he properly used it. I disagree, there is a dispute, and there's no evidence that there's no dispute. Additionally, for implied
There's a
warranty,
dispute, isn't there a fact issue then?
they have to prove, their burden is to prove that Mr. Harris properly used it, and they cannot do that.
It's not that they have to raise a fact issue as to that point.
For the record, there's not a fact issue because they have no evidence showing that he properly used it.
Response?
Yes, Your Honor. And again, plaintiff's burden here is more than a scintilla of evidence. We don't have to prove our case today. The evidence is that Neil purchased this e-liquid, used it in a commercially available e-liquid product that was intended to be used with the e-liquid. Defendants admit, the ingredients that were in their product. Those are, the ingredients that are in defendant's e-liquid product are the ones that are releasing carcinogens when heated. So there's really no dispute that these dangerous chemicals weren't in there at the time that it was produced.
Okay.
Your Honor, just as another brief statement, under Texas law, a product can be unreasonably dangerous, which is what plaintiffs seem to be saying is the defect of the vaping juices. But a product can be unreasonably dangerous while at the same time be fit for the intended purposes. And that is the standard that the implied warranty of merchantability is based on. It is not whether or not it's unreasonably dangerous, because there's a design defect for that. This is a specific defect, and plaintiffs have failed to show what that defect is beyond just saying it's inherently dangerous.
Your Honor, the intended purpose of this product is to be heated in e-liquid. And again, defendants are marketing this as a safe alternative to smoking tobacco. And it is not fit for that purpose. When it's heated to normal vape settings and temperatures, it's extremely carcinogenic, especially in the mid to high ranges. It grows exponentially to the point that in some instances, it's more carcinogenic, in this case, more carcinogenic than tobacco. So it is not fit for that purpose of which it's advertised as a safe alternative to smoking.
Your Honor, again, he's naming why plaintiffs believe that it was unreasonably dangerous, but under Texas law, it can be unreasonably dangerous while also be fit for its intended purposes, which is to be used as vaping juice, which is what occurred here.
The intended purpose is to be used as a safe alternative to smoking tobacco.
Your Honor, there is no evidence on the motion and on the record that shows that that is what defendant's intended purpose of the e-cigarette is.
All right, so on this one, I think this is really a close call. I'm going to take it under advisement and let's kind of see if there's any more cases. Let's talk about one last, I think that's the end of the, we have the plaintiff's motion for failure to mitigate. Go ahead and make that argument.
Your Honor, do you want to hit negligence on defendant's motion first?
Negligence is, I'm going to deny.
Okay. Yes, Your Honor. So the one issue that we have on our motion, defendants are basing their argument regarding the failure to mitigate on Dr. Carter's testimony that had Neil stopped or had he gone to a doctor sooner to receive treatment, he would not have died. They're saying that his failure to mitigate defendants are saying that Neil's failure to mitigate was the cause of his death based on Dr. Carter's testimony. As you recall,
Isn't it because of the big tumor in his mouth?
Is what because of the vape tumor?
Aren't they arguing that because of the big tumor in his mouth, if he had got that checked out sooner, he may not have had these issues?
Correct. And they're basing that argument on Dr. Carter's testimony that had he gone to get that checked sooner, he wouldn't have died. As you recall, Dr. Carter's testimony regarding causation of death has been excluded. So they don't have evidence to support their position there.
Response?
Your Honor, that is not the sole base of our failure to mitigate damages claim. As a timeline, sometime maybe early 2015, Mr. Harris started vaping. In October 2015, his tongue was cut at a dental appointment. Is testimony that we've provided for the record and that both his mother and wife and widow testified to that nick never healed. Sometime in 2016, early 2016, it was 4 or 5 months after Mr. Harris's dental appointment, he complained about his mouth. It was painful. His wife and mother asked him to go to the doctor. He refused to. When he finally did, it was a very large tumor that he had allowed to grow without seeking treatment for that. And Dr. Carter—
I'm going to deny on this one as well. So if you guys can put together an order on all of this, I think that's the last of it. Let's talk about the big picture here, which is you guys have a trial setting on March 29th, correct?
2022.
Oh, 2022. Never mind. Okay. I thought it was in a couple of weeks. All right. Then no worries about that. We should be hopefully fine for that. All right. Anything else we need to chat about?
Your Honor, on the implied warranty of merchantability, really quick as it's under advisement, I would just ask that you take a look at the 2015 video that defendants put out saying that the product was intended to help quit smoking as a safe alternative to help quit smoking.
Okay. And negligence was denied, just so it's clear. All right, guys. Well, it's great seeing you. Get me an order on that. If you don't mind when you prepare the order, Ms. Warren, if you could say that on what is today, March 12th, I think it's the day after my kid's birthday, so I should remember that. On March 12th, the court made the following rulings, just to make it clear, and try to get those to me. Give me the order by Monday so I can get it signed on Monday.
Yes, Your Honor.
Okay. All right, guys. Good to see you.
Good to see you.
Thank you, Your Honor.
Thank you, Judge.
Bye-bye. Okay. Let me get out the order on this. Okay, so I'm a little confused on this Zubarek case. There's an order that was submitted that I think I've already signed, but I heard from my coordinator that there was some question about the order or something, and so.
You're on. I don't think the order was posted online. I think you probably signed it and somebody didn't upload it.
Oh, okay.
And the only issue is that I guess Mr. Miller called your court coordinator and asked that the order not be signed. So.
Okay.
Judge, this is David Welch. The order is this case is closed and you entered a final order on December 4, 2020.
There's a final order on this?
Yes, Judge. You signed on December 4, 2020 an order to sever joint third-party petition. And at the end of that order, you have a statement in here that says, it is further ordered that the interlocutory judgment granting motion for summary judgment signed on October 23rd is now a final judgment with the severance. So you tried to sever some stuff out of this case and made this case final. October 23rd, you signed an order granting plaintiff's motion for summary judgment. So this cause number is final. I have not seen the severed case, but this cause number is final, Judge, is from my review of the docket.
Ms. Coker.
Your Honor, Mr. Welch's firm just joined, and I suspect that they are unfamiliar with the full procedural history of the case, so they're proffering that this is a final appealable judgment as of December 4th, 2020, and it's just, I will just chalk it up to they've just joined and haven't fully reviewed what's happened.
I'd like her to chalk it up to a signed order, please, Judge, and tell me where it's not final from your December 4 order. She can say and chalk it up and say what she wants to say. The orders are clear.
Judge, may I speak?
Give me 1 second. So let me make sure we're all talking about the same order. So is this the order y'all are talking about?
Yes, sir.
Okay, let's see. All right. This order, the interlocutory judgment granting is now a final judgment with the severance. But there was no severance. So, Ms. Coker, why? I know there's things that have happened since this order was signed. Kind of explain what's going on.
So, first, before assuming that the December 4th order was, as Mr. Welch proffers, a final judgment, before this court lost plenary power, the defendants filed their counterclaims, which then violates the one final judgment rule because of live pleadings that weren't disposed of in this order. And it says it's a final judgment, but it's not clear that it finally disposes of all parties and all claims. It's merely interlocutory. And on the severance, you may recall it looks like December 11th, 2020, so 7 days after, Mr. Miller filed a cover letter for the proposed order vacating the December 2020 order for severance. And Mr. Miller submitted an order to vacate order signed on December 4th, 2020, and in which Mr. Miller says the court signed by accident the order signed on December 4th, 2020, granting the severance.
Judge, can I hop in for a sec?
Well, wait. Can I? What date was that order? Second order signed?
that was the thing. Mr. Miller submitted it because my understanding is
That was
that
not signed, Judge.
Mr. Fell was a part of this and knows better than I did. But during the hearing, Mr. Miller decided to, oh no, I don't want everything severed. Let's not do that. And then wanted you to sign this order to vacate the severance and keep this case live. And all of the parties were in agreement on this.
Judge, that was never signed. In fact, there's a note on your docket that says you will not sign that. A hearing is needed or may need hearing. That's a note from the administrator on January 5, 2021. The truth is plenary power has run. You can't file a counterclaim after a judgment and say that keeps the case alive. TRCP 539, the only way to keep plenary the way Ms. Coker wants it is to file a new trial. That's not been filed, never was filed. This is a final unappealable judgment at this point. We're 90-something days out.
And Your Honor, what isn't limited by the appellate timetables is a judgment non pro tunc, because our position is the signature issues and the order and the confusion is merely clerical. COVID's happening right around the corner and everybody's working remotely. And there is no deadline to correct clerical errors in the trial court.
That's not true. It's 30 days. That's wrong.
So what orders have I signed since December 4th?
None.
Signed a scheduling order,
On what day?
an agreed scheduling order on February 1st. It's unbelievable that Mr. Miller is sitting here in silence, letting this argument be made that's contrary to what he represented in court.
That's not true, Judge. It looks like you did sign a scheduling order, but that's a scheduling order in a dead case 60 days after your judgment's been entered. That's a void order, the scheduling order is.
I mean, we've had countless hearings since that date. Why wasn't this brought up earlier?
The only thing I can say is because, like Ms. Coker said, I just got involved and I just found it. I don't know how the army of defense lawyers didn't notice this, but they didn't, and it's final.
I mean, the only thing I can say is I still have power to extend my plenary power under the emergency orders of the Supreme Court. My understanding is this, in this case, according to the county, the clerk's office is still open. It has never been my understanding that this case was closed. I thought that this was just an interlocutory order. If I neglected to sign that vacate, I'm not sure if that was my fault or someone else's fault, or it very well could have been my fault, but my understanding was that this case was not closed. Mr. Fell, is that your understanding, or what is your understanding?
Yeah, but may I share my screen with you briefly, Your Honor?
Sure.
So, Your Honor, the court signed the MSJ order on October 23rd. And it had, and at that time, it clearly was not a final order because it didn't dispose of all the claims and parties. So but you had some language in there that said the fences are to be come down in 30 days. So a motion, I filed it, I can't remember if it was joint, was filed for some clarification from the court, given that the order was not final at that time. And during this hearing, we had a big conversation. Mr. Miller was active in it, and he realized, as did everybody, that the severance really wasn't going to create any judicial economy, and he withdrew his request for the severance at that time. The court ended up signing it anyway on December 4th. Mr. Miller realized that it was an error. He writes this letter to the court, rightly so, saying, hey, you signed this by mistake. It was never the intention of anybody, including this court, for that order to be signed. And I think Ms. Coker is correct that Rule 316, if we needed to get that far, says that clerical mistakes in the record of any judgment may be corrected by the judge in open court according to the truth or justice of the case. Truth or justice. Like I said, I can't believe Mr. Miller is sitting here in silence, allowing this argument to be made.
Judge, this is all for naught. It doesn't matter what was argued or said or anything. We're 98 days past what you've identified as a final judgment in a written order. If they wanted to make these arguments, they should have made these arguments. I know the court said the court believes it has plenary power to extend the deadline on the judgments due to the COVID orders. I don't have the ability to look that up right now. I would like some time to look at that because I don't know if you get to extend your judgment plenary power this far out. Here's where the issue is, Judge. There's an inspection that would be going forward on Monday if this case is not closed. So we had this emergency hearing set by the administrator this morning to figure out what's going on. My position and plaintiff's position is there's a final judgment, this case is closed. Whether or not it was the intention of everyone or not, it's too late now. That inspection should not go forward. That's what defendants are trying to push. If we need to have another status conference or figure out what's going on next week, we can with some full
So this
time
is what I'm
debrief.
going to do, Mr. Welch. You're brand new to this case. I'm a little
Yes, sir.
surprised Mr. Miller's not talking here. It was never my intention. I understand you feel like you have a gotcha here. It was never my intention to do that. Pursuant to both the arguments on non-pro-tunc and the emergency powers I have under the Texas Supreme Court, I'm going to vacate that order of severance. I thought that I had vacated. I guess I didn't sign the vacate. So for both those reasons, I'm going to sign it. Go ahead, Mr. Fell, and prepare an order on that. The inspection is going to go forward as ordered on Monday. I signed the order just now. Anything else?
Judge, if I may,
Thank you, Your
yes,
Honor.
if I may, for the record, and for purposes
You've
of
made your
appeal.
record, Mr. Welch. So we've.
I understand.
All right. Thank you, guys.
Thank you.
Thank you.
Your Honor.
Hold on that, Mr. Fell.
Happy birthday to the twins.
Thank you. You guys have a great day.
Thank you, Your Honor.